So promissory estoppel is a very incredibly powerful tool for you as an equitable doctrine. So this is moving into the week 4 slides, which is now getting us up to date, hopefully. But let's say you have one of those elements missing, and that element is consideration. Promissory estoppel can come in to fill the gap and make the agreement binding because it would be unfair not to. So fairness comes in. So if, let's say, you have a fact pattern that's got no consideration, and you go through your rules and application, and you still, in your conclusions, say that there's no valid consideration. It was past, it was not nominal, for example. You would then look to see whether we can evoke the doctrine of promissory estoppel. And if you can satisfy this principle, then the agreement will be binding. So it's a rule of equity that prevents an unjust departure by a person from an assumption of fact that they have caused the other party to adopt. You've promised them something, they've relied on that promise, they've acted on that promise, then you should have to fulfill that promise in equity. And the reason why we call it estoppel is it's preventing that person from going back on what they said they'd do. So definitely in cases of deception, promissory estoppel will be applicable. Definitely in cases of deception. In the case that we had, Walton Stores and Mayer. This case is incredibly important. 1988, and what it did was expand the ways that promissory estoppel can be used. Now, historically, it was used more of a shield to prevent obligations. But this case makes it a sword so that you can use it to enforce or create a binding obligation if it is satisfied. Here we have Walton Stores and a couple called Mayer. Mayer owned this land with some existing buildings on it, some newer than others. And they enter into discussions with Walton Stores to lease out some of their land. As part of these discussions, it's decided that they would demolish the buildings that already exist and erect new ones to the specifications of Walton Stores. They're going to set up a big store. They've agreed to terms on rent, and because it's a lease arrangement, there has to be a written agreement. That's the requirements of a lease. So automatically we have a formality that needs to be complied with. Now they're starting to have these conversations, and there's some back and forth between the solicitors on drafts in the lease, and they start to do the works before the contracts are signed. Now this includes demolition and a complete restructure. Now the Mayers are starting to get worried because they've done all this work, they've demolished all their buildings, and they go back to the solicitors of Walton Stores and say, we need to hurry this up. Let's get these documents signed. Anyway, Walton Stores are starting to have reservations because they want to go somewhere else now. They don't want to open up in Nowra, in New South Wales. And they decide to instruct their solicitors to go slow while they make up their mind. What that means is, don't give them a signed copy back yet. We want to think about it. But at this time, Walton Stores are very well aware that the demolitions happened and that 40% of the buildings have been erected. And they're aware that those buildings are being erected for them, to their specifications. Anyway, after that 40% is complete, Walton Stores decide that they're not going to proceed, and they inform the Mars that they're going to not lease that property. There's no signed agreement, so they don't have to. Obviously, the Mars are a bit upset by this because they've done all this work. They've put the effort in, and they're in a bit of a situation where they're stuck. So the question is whether promissory estoppel can be used to enforce the agreement, that promise that was made. And what this case gives us is the elements that we need to prove to satisfy promissory estoppel. And that first element is an easy one. The promisor has made a promise. In this case, it's a promise to lease out the land and the buildings for a significant period of time. It was a long lease. Secondly, the promisor creates or encourages an assumption that a contract will come into existence or a promise will be formed. And because of that assumption, the other party, or because of that encouragement, the other party relies on that and continues to their detriment to act in a certain way. So you've got a promise, an encouragement of an assumption of a particular set of facts, and that person relying on those facts to their detriment. First three elements. But the fourth one is where your arguments really come in. And you have to show whether it would be unconscionable. Now, what this term unconscionable means is really unfair. It would be manifestly unfair in the circumstances, having regard to the person's conduct, to ignore that promise. So if you can satisfy all four of those elements, you can satisfy promissory estoppel. So we can see that there's a promise. Do we think that Walton Stores have encouraged an assumption in the Mars to continue doing the work? There's at least some evidence there to suggest that they've encouraged that by not really doing anything to tell them otherwise. They only told their solicitors to go slow. They never told the Mars that, hey, we're thinking twice about this, maybe you should slow down a bit. We know that by this silence that the Mars have relied on their detriment because they've continued to do the work to such a degree that 40% of it's done. And in the circumstances, it would be unfair for Walton Stores to go back on their promise because of the costs associated with that. So in this case, the contract was enforceable in terms of they were stopped from denying the existence of the contract. Even though the lease had not been signed, equity stepped in. Now, the other elements in this case were that there was an element of urgency, and Walton Stores knew this. And they didn't say or do anything about curbing that assumption of that urgency. The other is that they had this executed and forwarded draft. They had it ready to be signed. So the Walton Stores just thought, well, they haven't signed it yet, but they haven't said anything, so it must be okay. So we'll take the silence as something that is not going to be detrimental. So the inaction in those circumstances, and what we mean by the inaction in the circumstances is that they were full aware of the work that was going on. And by not doing anything, that was unconscionable. Does that make sense? So whenever you get an promissory estoppel question, make sure you apply those four elements. Discuss them. And just reference Walton Stores and Mayer as your case. So real quick question. We've got Alf. He's decided to give up his successful business to help his elderly parents on the farm. He's not going to get paid for this. And he goes and works on his family's farm for many years. Now, several months ago, Alf decided to marry and was keen to go back to his old business or his old job. Now, knowing this, Alf's parents promised that, well, don't go back to your old job. You can continue working on the farm and we'll gift you or give you part of the property. This happens a lot in farming families. And then with that land, you can build your own home. So Alf relies on this promise. He continues to work on the farm, and he goes and gets a large bank loan to pay for the construction of this new home. Now, the parents had promised him that they'd go to their lawyers and arrange for the transfer of that title. However, after some months, and with the house almost complete, being built, the lawyers haven't finalised any contract yet. Now, unknown to Alf, the parents were reluctant to proceed with the arrangement because they wanted to give it to another sibling. This also happens a lot in farming communities. There's always a favourite at one stage, and they change their wills a lot. But anyway, I digress. The parents then told their lawyers to go slow with the preparation of the contract. Alfred's gone to the lawyer and going, well, what's going on? and now his parents decide that they're no longer going to sign and they want him to leave the farm immediately. They're literally kicking him off the land. So our job is to advise Alf, using common law, whether he has any rights against his parents. Now, it's really important that you read the question carefully, because what it's asking for is your advice based on common law. If it is just asking for common law, we just apply case law. You do not have to apply statutory law. So it's a signpost to say, you know, you don't need to reference any sections of legislation. If it just said, advise Alf to the relevant rights he has against his parents, you would talk about common law and statutory law. And then on the other side, if it just said, advise on statutory rights, you just have to talk about statute. It's very rare that you'll ever get a question like that, because we need cases to support how statutory law is applied. So using our IRAC method, what's the issue? In a real pure sense. Can the parents renege on the agreement? Excellent. So that's our issue. And in particular, whether Alf can use the doctrine of promissory estoppel to help him out. Because what are we missing in a pure contract form? We're missing a contract, of course, and it's needed for land. Absolutely. The formalities haven't been complied with. We've got an offer and acceptance, and we probably do have some level of consideration. So our issue statement is this one sentence that says, can Alf rely on the doctrine of promissory estoppel to enforce his agreement against his parents? Then we can spell out our rule for promissory estoppel, which is our 4 elements. Promiser makes a promise. The promiser creates or encourages an assumption of some facts, and that person relies on that assumption of facts to their detriment. And it would be unconscionable to do so. So do we have a promise here? Absolutely. And what's the promise? Excellent. To give him part of the land in exchange for him working on the farm. Is there an encouragement of that assumption? Absolutely. He says, you know what, I've had enough of working on the farm, I'm going to go get my job. And they go, well, you do this, we'll give you the land. They also never tell him that they're changing their mind or going slow at any stage. So that inaction is encouraging that assumption as well. Has he relied on it to his detriment? Absolutely. What's happened to his detriment? He started building a house. He's got a bank loan. So if they were to not go back, if they weren't to fulfill their promise, he spent all this money. So in those circumstances, is it unconscionable? Who would say yes? Who would say no? It's probably unconscionable. Now, unfortunately for us, we don't really have a pure test for what unconscionable is, but what you do is you just go by the feel. It's the vibe. It's Marbo, the castle. Does it look bad? Does it smell bad? It probably is. That's what unconscionability is. We do have some cases to help us say, well, courts have said this is unconscionable in the past, probably going to be unconscionable now. Now, we look at unconscionable conduct in more detail with vitiating factors, particularly in the example of Amadio and the Commonwealth Bank, where the Commonwealth Bank got an elderly couple to sign up to a loan guarantee that they should never have been required to sign up to. It was unfair. But just look, does it go against conscience? And in this circumstance, you can see that the parents have created such a thing that would be incredibly unfair for them to deny the transfer of that land. So you've got a promise, you've got someone relying on that promise, they've promised that they're doing it. I promise I won't say promise so much. And it's unconscionable, given the conduct. So we've got a clear expectation between the parties. He expects to get the farm. He gives up his job. He marries and moves in. He does some work. He's relied on this expectation. And the parents knew and encouraged him in this assumption. They promised to keep him working on the farm. That's exactly what they're doing. So unconscionable conduct. Alf's going to win. And there's just a very quick definition of unconscionable conduct. So having no conscience, not controlled by conscience, unscrupulous, unreasonably grasping, whatever that means, and extortionate or harsh. Things that are just unfair. Cool. There's one element of contract formation left, and that's intention to create legal relations. How about we rush through it, because it'll only take 10 minutes, and then have a break, and then we can cut contract formation and only come back to it on the research assignment. How's that feel? All right, so the last element of contract formation is that the parties need to intend to be legally bound. If you do not have an intention to be bound, the courts will not enforce it. And what I mean by this is, let's have a circumstance where you invite a friend over for dinner. Your friend doesn't come. You get upset. You sue them for breach of contract. In those circumstances, the courts would hold, well, this relationship is not one where you were intending to be legally bound by that promise. They're not going to enforce those social or domestic contracts that do not have the requisite intention. This is very different to, let's say, a contract in business where it's very clear that where you're selling goods or buying goods that you intend that to be binding. But intention to create legal relations we can split into two aspects. The first one being social and family, the second being business. Now the courts apply what we call an objective test, not a subjective test. So what they do is they step back from the parties. The reasonable bystander. What would someone who is observing the behaviours or the transaction taking place think in terms of, by the way that they've acted, did they actually intend to be legally bound? So it's not what the parties are arguing, it's what a reasonable bystander would assess the situation to be. Now, generally speaking, a reasonable bystander would be saying that when you invite friends over for dinner, there's not really an intention to be legally bound by that. Similarly, you promise to wash the dishes. Taking a bet with a friend can be a little bit more blurry though, can't it? So the circumstances from an objective perspective need to be considered. In business, you may rent property, sell goods, but you can see that that intention is much easier to identify. So what we have in the concept of intention are these rebuttable presumptions. Now, a rebuttable presumption is something that the courts use to say that something is true until proven otherwise. An example of that is the presumption of innocence before proven guilty. So that person that's on trial is innocent until the prosecution proves otherwise. Rebuttable presumption. So in intention to create legal relations, the courts have this rebuttable presumption that social and domestic agreements are not intending to be legally binding. So friends, family members, their agreements are presumed not to be legally binding unless there's evidence to suggest that they were intending that to be legally binding. Now the case of Balfour and Balfour is our first one that we use to identify or demonstrate that presumption. Balfour and Balfour are a husband and wife, and they were initially living in Ceylon, I think in Sri Lanka, and they've travelled back to England for a period of time where the wife has then fallen ill. The husband has had to go back to work in Sri Lanka, so he's travelled, but left the wife there and promised in exchange that he'd give her £30 a month. So you stay here, I'll go to work, and I'll send you money so that you can survive. He did that for a while, and then the couple grew apart over time, and then he just stopped sending money, and she decided to sue for breach of contract. Now, what the courts are saying is, in that matrimonial relationship, yes, partners give money to each other as a semi-type of maintenance approach. But between a husband and wife, there is no intention to be legally bound when you make an agreement for the payment of each other of money. The domestic relationship creates a circumstance, this is the presumption, that that contract will not be legally binding. Now, let's change this a bit and let's make it about separating spouses. Merit and merit. We've also got a couple here who are making a promise, and in this promise, the husband says, well, you live in the house, there's only £140 or something left on the mortgage. I'll pay to you a monthly sum, let's say £40, and if you then pay the mortgage off, I'll transfer the title to your name. This is after they've separated. It's kind of a, yeah, I'm going to leave, but this is what we're going to do. Now, she paid off the mortgage based on the money that he was providing, and at the same time, or at the time that it was paid off, he refused to transfer the title. And the courts have said, well, yes, although it's a domestic and social arrangement, we can see that in the circumstance where a couple is separating, there is an intention that that agreement be legally binding. So the presumption can be overcome where you've got facts to show that that intention existed. So we always start at the presumption. You have to first overcome the hurdle. Another case we have is Wakeling and Ripley, which, to be honest, just looks a lot like promissory estoppel. And in fact, it is. And here we've got a circumstance where Ripley, an old man who lives in a house in Sydney, has written to his family in England, the Wakelings, and told them that, hey, if you come live with me and look after me, I'll let you live in the house rent-free, and then I'll leave the house to you after I die. It'll be in the will. So what the Wakelings did is they picked up from England, quit their jobs, sold all their property, and moved to Sydney, in with Mr. Ripley. Now, after about a year, they had a serious fight. Mr. Ripley kicked them out and changed his will so that they no longer were in the estate, or they were no longer getting the property. Now, they sued for breach of contract. Now, we can automatically see promissory estoppel, and it should be ringing an alarm bell. There's a promise, a promise has been encouraged, and they've relied on that encouragement to their detriment. Because what they've done, they've left everything in England, come to Australia to live based on this promise. But similarly, you can see that there is enough evidence to rebut this presumption that a domestic and social agreement is not binding. The seriousness of the promise was enough for the courts to say, well, a reasonable bystander would expect these parties to think this is legally binding. So because of the seriousness of it, you can overcome the presumption. And we have exactly the same case again in Riches and Hogben, but we've got a son moving from England, same circumstances, to live with his elderly mother, who promised him a house. Now, similarly, he sold everything in England, but he only lasted with his mother for 7 days until she kicked him out. A bit more extreme. So he sued, claimed that it was a contract that was more than just a domestic arrangement, and the courts are saying similarly to Wakeling and Ripley that yes, the seriousness of this is enough to satisfy that presumption that's been rebutted. So what this means is if you get a research question that has family members, the first thing you need to do is prove whether that intention or that presumption that no intention exists is rebutted. So you go through Balfour and Balfour to say, yes, there's a presumption, and then you go through your other cases to say, well, that presumption's rebutted in the circumstances because of the seriousness or because of it's clear that the intended parties wanted to make this a binding relationship. Now flip that to commercial agreements. There is a presumption that commercial agreements are intended to be legally binding. So if you've got a commercial agreement, you go straight to that, unless there's evidence in the facts to suggest that the parties did not want to be bound. In Rose and Frank, we had a contract that had an honor clause, which just means that this contract is not intended to be legally binding. We're only entering these words or writing these words to show our mutual respect and obligations. It's kind of like a memorandum of understanding. Has anyone seen a memorandum of understanding? It's where parties exchange an agreement. I hate memorandum of understandings, but anyway, that says they'll just cooperate. And then they'll have a clause that says, this contract is not intended to be legally binding. So what's the point of it? I always ask, but people like the ceremony because you get all the big prime ministers around, they sign this memorandum of understanding, they get their KPIs, but no one's actually bound by anything. If you've got an honor clause like that, or something so clear that says we're not intending to be legally bound, this presumption for commercial agreements to be binding is overcome or rebutted. And that was the case here in Rose, Frank, and J.R. Compton. We had two businesses that were long-standing relationship. It was a healthy relationship. They just had an agreement to step out kind of what they would do when they would do it. But it was an honor relationship based on mutual trust and loyalty. So when something went wrong, the courts refused to enforce those terms. I should note with memorandum of understandings, even if you have a clause that says this is not intended to be legally binding, if the provisions themselves are so operative that they create obligations, I would almost say that that clause becomes inconsistent with the rest of the agreement and can be severed. And we'll explain that when we get to terms. But just because you sign a contract that says you're not intended to be legally bound, you need to also consider the rest of the terms as well to see whether there are obligations that may say that's not the case. Don't just sign MOUs because, I don't like them. But that's me. An example problem, then we'll have a break. A group of friends meet for a regular drink at a hotel every Friday night. Each contributes $2 towards a group lottery ticket, which is drawn over the weekend by a lotto company. Now, one of the group is given the role of actually buying the syndicate ticket. So let's say there's 5 friends, they collect $2 per week, and they get a $10 ticket. When a winning ticket is finally drawn, the person who purchased the ticket claims it for himself and says, well, there was no intention to be legally bound because this is a purely social and domestic arrangement. We're just friends. No intention to be bound. So he doesn't share the prize. The question is, do we think that there's an intention to be legally bound in this circumstance? Yep. There's the considerations, there's a money exchange. But just remember, with Balfour and Balfour, there was money exchange as well, but the relationship was one that didn't create an intention. You're on the right track, though, and I think you're 100% right that the money was exchanged with some level of intention or expectation that it was put towards something. Absolutely. So I think you can say the dynamics of the friendship group are of such that they probably intended to be legally bound. That is totally an argument that I think is up to you to run with, but I agree. The money is a thing that is an important factor. I'll leave that with you to think about. How about we have a bit of a break? A 10-minute break. What we've done then is completed contract formation, and then we'll just move on to capacity and terms now, but we'll come back at 5 to 8, and if you've got any questions, please come see me in the meantime.